I'm Shannon McNulty, the founder of the Village Law Firm and an estate planning attorney, and I'm here with my colleague, Joe Stackhouse, who is also an estate planning attorney. Joe, do you have anything you want to add?
We're going through a huge transition right now, and a lot of people are frankly terrified, especially when you look at social media because it's just getting darker and darker on there. We're here to hopefully help people understand the past, the present, and how to plan for the future.
So this is just a little bit about us. In terms of what we're going to be covering today, we're going to be looking at kind of where we came from, where we are now, where we're headed, and protecting yourself in a hostile political and legal environment. I just want to talk about kind of what are the US constitutional provisions that affect gay marriage. So in terms of how the legal structure works, the protections and also the threats come at a lot of different levels. And so it's helpful to understand what the structure is and how those different pieces interact. So to begin with, most marital and family laws are reserved to the states. Jurisdiction over family and matrimonial law is generally reserved to the states under the 10th Amendment. Okay, so we kind of want to start from that standpoint of the states are the primary regulators of matrimonial and family law. Under the full faith and credit clause of the Constitution, states must recognize the laws and judgments of other states, and Congress has some role in that recognition process and setting standards or restrictions on that. It's a little bit unclear exactly what Congress's role is, but there is some role that the Constitution suggests. This means that generally, traditionally, if there is a marriage that's commenced in one state, and then it should be recognized in another state. So traditionally, even aside from LGBTQ issues, if somebody gets married in New York and they die in, we'll just say, Ohio will basically say, okay, because they're married in New York, they have the same, we'll treat it the same in terms of like whatever our matrimonial laws are with respect to inheritance, healthcare rights, things like that. So states have to respect other states' judgments. The 14th Amendment requires equal protection under the law of all people under the jurisdiction of the US. And that is something that 10th Amendment. So the 10th Amendment says matters are reserved to the states, but the 14th Amendment says, okay, but the states cannot, and the federal government cannot, breach equal protection of Americans under the law. So that's where kind of the background of these legal protections and provisions. Okay, so in the early days, same-sex marriage is just illegal throughout the country. There is no place where you can get married or have that marriage respected. There was an early case in 1971, which was the first legal challenge to Minnesota denial of a marriage license. The Supreme Court dismissed the case. So it basically, that was the first legal challenge, but it didn't change the landscape. Joe, do you want to talk about like what practical impact did that have beyond just not being able to get a marriage license?
Beyond not being able to get a marriage license, other things get affected in terms of, things that take into account whether you're married to somebody. Things like taking the spousal deduction when you file for an estate tax and you want to take a deduction for any property that passed to your spouse. People couldn't get that. In terms of who could adopt children, certain states have rules that say only married couples could adopt children. And so even if you were a same-sex couple living together, you were not able to adopt. Other things like being able to visit your loved ones in the hospital, being able to inherit. Here in what we do in estate planning, we have rules involving if you die without a will, who can take things, and usually your spouse is the first person on that list. Well, if you can't legally marry them, your spouse doesn't have any, they're a stranger to your estate. So security benefits in terms of immigration and citizenship, being able to marry somebody who is in the country, and then also the ability to receive your spouse's benefits after they pass away. So all these things, these benefits, these things that people can have are dependent upon being married. And so even if you live with someone, you build a life with them, if the law doesn't consider you legally married to them, you're a stranger to all of these things.
Okay, so the first legal victory that we had was in Hawaii, that a court held that the state's ban on same-sex marriage violated the Hawaii Constitution. Hawaii quickly moved to amend the Constitution and to ban gay marriage, but this did kind of set off a series of events, and particularly it was around this issue of the full faith and credit clause. And if one state did allow same-sex marriage, then would all states have to recognize that marriage? And that became a big concern. And for that reason, we had, so it's kind of the dark days of the Defense of Marriage Act, DOMA, in 1996. And Joe, do you want to talk a little bit about what DOMA did?
So what DOMA did, and just for the sort of what DOMA did was it set a definition for marriage for federal purposes, which says we define marriage as between two people of opposite sex. That was a law passed by Congress. It was veto proof. So even if President Clinton at the time didn't sign it into law, if he vetoed it, it still had enough votes behind it to go above a veto. So essentially, it allowed the states to refuse recognition of same-sex marriages performed in other states, and then also denied, federal rights to same-sex couples who are married in one state. The federal government did not have to recognize that marriage if it didn't fit within the federal government's definition of marriage.
After DOMA, the next few years, we did have some early successes. Vermont in 2000 recognized civil unions. Massachusetts Supreme Court declared a ban on gay marriage, that declared that the ban on gay marriage violates the state constitution. Some states enact civil union, domestic partnership laws. Others recognize marriages that were entered into in other states. In New York, in 2011, New York passed the Marriage Equality Act, providing equal rights for same-sex marriage under New York state law. And what this did was there were additional rights. So under state law, there were rights, but they're still, because of DOMA, that the rights that somebody may have obtained in, say, New York or Massachusetts, they didn't travel, they weren't transferable. So if you traveled to another state, then say if you were in the hospital, then they weren't necessarily, your spousal rights wouldn't necessarily be recognized in that state. And because of DOMA, also any federal rights were still not available. So again, like the federal estate taxes, federal income tax benefits, Social Security, spousal benefits, all of these things that were still not available, even though there was some progress on the state level. Okay, then the next phase is where DOMA was ruled as unconstitutional. Joe, do you want to talk about what happened in United States v. Windsor and what that
Sure.
gave?
Sure. Yep. So, Edith Windsor, who actually was an alumnus of my college, Temple University, um, was married, and when her spouse passed away, she filed a state tax return and wanted to claim the marital deduction. And the way that a lot of times this works in terms of if you have a dispute with the IRS is you'll file the return, you'll pay whatever the tax is, and then sue for a refund. So Edith sued for a refund based on the marital deduction. And the IRS, denied her because under the DOMA Act, uh, marriage is only marriage is only between two people of opposite sex. So it went to the Supreme Court. And when it got there, the Supreme Court ruled that, in fact, DOMA did violate the Equal Protection Clause, and thereby setting the standard that, no longer could the federal government uh, say that marriage was just between a man and a woman. They could say it could be between couples of the same sex, and that they should be, as long as the marriage was legal in the state where they were married, then the spouse would be able to claim all those benefits, such as the marital deduction for tax purposes, Social Security, military spousal benefits, all of those things. However, it did not change states' ability to ban marriage. And whether other states had to recognize other states' marriages.
Okay. And so this next and kind of more, this was really the kind of, well, quite almost the final, but this was a big, Windsor was very big, and then this is sort of like the next domino to kind of fall. You want to talk about Oberfeld and what that meant?
Sure. So in Obergefell, it was I believe 6 different cases that came together out of Ohio, where the unique sort of circumstance in a lot of them was a spouse passed away and the remaining spouse wanted to be named as the spouse on the death certificate for that spouse. And they were all married, all these, were married in other states, New York, I believe one was in Maryland. And Ohio does not recognize other states' same-sex marriages. What the sort of interesting thing is they'll recognize all other types of marriages, such as, certain states allow you to marry your first cousin, things like that. They would recognize those marriages, but they wouldn't recognize a same-sex couple's marriage. So this went all the way up to the Supreme Court. And what the Supreme Court did was, for the first time, define same-sex marriage as a fundamental right. And by doing that, then nationwide, states could not, take away that fundamental right, and which means that if you were a same-sex couple, you're allowed to be married, and you were entitled to all those different benefits and those rights and responsibilities as you have with a spouse, even if you were of the same sex.
Okay. Great. Okay. So, and this is I think the final stage where the Windsor and Oberfeld were through the court. So that was through the judicial branch and establishing that certain things were unconstitutional, but it was not affirmative legislation. So it was about what couldn't be done, but there was not affirmative legislation. And so in 2022, Congress enacted the Respect for Marriage Act. And this was federal recognition of same-sex marriages, and it requires states to give full faith and credit to marriages that were licensed in other states. That's something that wasn't necessarily addressed by the court. And this just provides additional legal security, protecting, and it's, importantly, this protects federal marriage rights from future judicial reversals. So even if Oberfeld were reversed in the future, as long as the Respect for Marriage Act continues to be in force, then this provides at least federal protections, and also the full faith and credit, that transferability protections. Joe, do you have anything to add to that, to this development?
No, I think you pretty much succinctly summed it up. And other than just so the kind of understanding of how these sort of processes work, because I think we're going to start talking about sort of the pitfalls that are coming in the future. But you have this interplay between, what the president and the police can do, and then what the Congress laws can pass and what the judiciary can do in terms of interpreting the law. So you have it where courts will make these decisions, and then you have the legislature actually enacting it into statutory law. But then this just opens the door for, the more judiciary interpretation, and for the executor to decide how are police and state officials and government employees actually going to carry out this law or enforce this law. So that's sort of the interplay that we're starting to see here is it's just those three levels coming together and starting to sort of mesh together. And even in some ways, compete to see who's getting on top, who's going to have the final say in the argument.
Great. Okay, and so these are just, even though we've made so much progress legally, there are still issues that come up. And just because a law is on the books, and just because the Supreme Court says something's unconstitutional, some people don't always follow the law. And this is really what has been a continuing issue. I think the most famous one was Kim Davis in Kentucky, the county clerk who refused to provide a marriage license. She was actually jailed by the court, held in contempt. The court awarded damages and fees. Probably less known was this happened even in New York, a small town near Albany, where the clerk refused to provide a marriage license, and the State Division of Human Rights had to intervene and a settlement was reached. And that was very recently. So there continues to be challenges in this area, even though the law that's on the books is quite clear. Other issues that can come up are in the realm of parental rights. A lot of times couples think that as long as the two parents are on the birth certificate, that will be a proof of parentage and that will secure their rights as parents. But that doesn't necessarily isn't going to provide the best protection for your parental rights, because it's not a formal judgment, and a formal judgment is what's needed to provide that full faith and credit protection in terms of having it be transferred and recognized by other states. So this was more difficult prior to 2021, that non-biological parents had to do a second parent adoption to really secure their parental rights. In 2021, New York implemented the Child Parent Security Act that provides streamlined process to obtain that parentage judgment. But if your child was born before 2021, you probably want to get a second parent adoption just to have that extra protection. Even after the Child Parent Security Act, you still have the option to do a second parent adoption, and you may, in this legal environment, want to do that second parent adoption just to make sure that your rights are recognized across state borders. Okay, and here we come to the new political landscape. And I think it's important to understand that even if the law doesn't change, we are just in a very different environment. And it seems that where we've seen in other areas that despite the laws, that we're having just government officials ignoring the laws, we're having judges ignore laws and precedents. And so I think what I would expect is we're going to see more frequent refusals to comply with the law as it's written, necessitating legal challenges. And these may be even planned legal challenges. They're denying these rights specifically so they can bring them to court and challenge some of these precedents. So I think what kind of practically that can mean is that we really can't rely on states respecting the law, especially states where that is a more hostile political environment. And even if the law is upheld and there is the legal victory, this is still, it's not equal rights, because if you have equal rights, you shouldn't have to be fighting in the courts for them all the time. And so even if eventually they're recognized, you're still dealing with delays, you're still dealing with legal fees. This could be, there's a law on paper, but in effect, it's not really helpful. You know, if there's somebody in the hospital and you can't see them, and there may be a limited time in which you can do that, the fact that like a year later, the Supreme Court holds that you should have been allowed to see your spouse is not really going to be helpful. So I think it's really important to just understand what protections the law can provide, and then what sort of the legal or the political environment, how that interacts with the law. So I think I don't foresee there being changes in New York. I mean, we never know in the future, but I think in the more immediate short term, we're looking at potential changes at the federal level. And we have those two protections at the federal level. We have the equal protection decision in Oberfeld, and we have the Respect Act at the congressional level. If Oberfeld is reversed and the Respect for Marriage Act remains, states must still respect marriages performed in other states under that full faith and credit clause. So, and federal rights remain for married couples. The difference would be that some states may deny marriage licenses and they can deny state rights, but it wouldn't affect rights at the federal level, and it wouldn't affect if you are in a state that recognizes those rights and protects those rights, you would be protected. The really risky thing here is if you're traveling outside of a friendly state to another state, that can be risky. You may be risking not having your rights respected. If Oberfeld is reversed and the Respect for Marriage Act is repealed, then there are even more challenges and loss of protection. So here we are looking at the loss of federal benefits. We're looking at the loss of spousal tax benefits. We're looking at the loss of Social Security benefits, immigration, citizen sponsorship, and for federal employees, spousal benefits, and also the loss of that full faith and credit, that interstate marriage rights. So if you are married in New York or another state that recognizes same-sex marriage, if you travel to another state, that may not be recognized, and not just in terms of practice, but also in terms of the law. Okay, so where does that bring us to? Given the situation now, I think we have to look at like how you can protect yourself. Joe, you want to talk about some of the things that you can do to protect yourself and your family?
Yeah, so having your estate plan in place is extremely important, because generally you can appoint whoever you want as your executor, your trustee, your healthcare proxy, your power of attorney. You can leave your assets to whomever you want. If, you know, it's when these things are not in place that the default rules of the government come into play, and that's where we run into problems with your assets can go to your spouse, but if you're not legally considered legally married, then, then your spouse is a stranger to your estate. So by having these things in place, putting in your healthcare proxy, I'm appointing my partner, my spouse, as my healthcare proxy. That way, they'll be the person who can make decisions for you. Same with tax planning in terms of making sure that okay, maybe you can't qualify for the marital deduction, but if you can set up a plan to get things out of your estate so that the marital deduction is not even an issue, and then you can sort of work through that. You can sort of get around those sorts of issues if the IRS will not recognize your marriage. For financial planning, life insurance, Shannon, you have a standard formula that I know that you sort of recommend to people in terms of how much life insurance to get to make sure that in the event you pass away, somebody can still be supported and still live and still survive. Your spouse, partner can still survive if you were to pass away and they're not able to collect things like your Social Security benefits, your pension benefits, your retirement benefits, or whatever the case may be. A lot of people, semi-joking and then more seriously consider just leaving the country. And I've actually recently found a handful of people I know who have done it. It is an option, but there's definitely tax consequences to doing that. And the process of doing it is very complicated and expensive. Renouncing your password or your passport and paying the expatriation tax and et cetera. It can be very, very time consuming and expensive. So before you sort of we live in a country where we tax based on citizenship. We don't necessarily tax based on where you make your income. So going to another country, you're still going to have tax responsibilities here, even if you're making money in another country. So you should definitely consult an attorney, a tax attorney, and revise your documents and make sure that you have a proper plan in place if that is what you feel like is your option, like you have to leave the country. It's definitely not something that you can just take off and do. And I think that overall, it's just making sure that you have a plan in place and that every T is crossed and every I is dotted.
Thank you. Yeah, and I think that really, hopefully this is not where we go, but realistically, I think we need to think about these things and put more protections in place for ourselves. And I think this is kind of like the reason why I started with where did we come from is because that may be where we're going back. And these were the things that we needed to make sure that were in place prior to all of the progress that was made. There are still things that you can do to protect yourself. You're not, there are steps you can take so you can feel like you can do some things that are proactive. And like Joe said, a lot of the in terms of the legal planning for your inheritance, for your incapacity, your health care, in the US, at least this is one of the good things, like you do have choices with respect to those things. So there are default rules as to who has those rights if you don't have the documents, but those documents in almost every situation, they trump the default state law, so you can affirmatively choose whoever you want. Even if in a heterosex couple marriage, you don't have to choose your spouse. You can choose somebody else as your healthcare proxy. You can leave assets to somebody else. So, so there are things that you can do. And in terms of leaving the country, it is, I don't think it's a bad idea to just explore some options of what other countries can you qualify for citizenship in? Are there countries that you can qualify for a visa in? I know, unfortunately, a lot of countries are also in a similar environment with immigration with respect to it becoming harder and harder to move there, but those are things that it might be a good idea to do. I would also add for immigration, if you want to, if you're relying on being married to get your citizenship or a visa or something, I would do it. Like I would do that now because it's possible in the future you may not have that option. And so getting that immigration status, I would go ahead and do that. I wouldn't wait for that. And this is just in terms of we do help clients. A lot of our clients are in the LGBTQ community, and we do help New Yorkers and of every sort of stripe in terms of protecting themselves and their families. And if you have any questions at all, you could feel free to reach out to us, either myself or Joe. We'd be happy to talk to you. And Joe, do you have anything else you want to add?
No, you know, hope for the best, plan for the worst is really the best advice we can give. You know, I try to stay optimistic that things cannot possibly be as bad as they seem and people cannot possibly be so bad, but um, you know, keep that in mind, but then also just make sure that you're prepared for whatever comes. You know, preparation is key.